And may I turn the floor to Queen Sarah McCurry. Thank you.
Thank you very much. It is my pleasure to join you this morning. It's this evening for me here in Canada. As you heard, my name is Sarah McCurry. I'm an access to justice strategist, and I specialize in issues of judicial integrity and support to judiciaries. I have been working with the UNDP out of the Bangkok Regional Hub on the Judicial Integrity Network's ASEAN Region Initiative, the one I'll be telling you about more today, as well as with the UNDP's global program to look at emerging technologies in the court context. I really appreciated the opening remarks talking about the importance of learning from mistakes that we've made in other parts of the world and finding ways to also learn from each other in the region. With everything that I talk about here this morning, there are good lessons to learn to make sure that we build on each other's experiences, and at the same time, a recognition that the best solution will always be a little bit different based on the court structure, the culture in the justice system, as well as the culture within each country. Looking to find ways to build on those learnings is a key part of how we move forward for judicial integrity. Today, I'm going to focus on some recent research and findings about emerging technologies and the impact that these technologies have on judicial integrity. I know that you will also hear from others who have been looking at these issues, both within Thailand, as well as from my colleague, Nicholas Booth at the UNDP, focusing on the impact of the pandemic in this context, and some of the initiatives and innovations in other countries specifically. I think this is a very exciting and positive learning opportunity, and I'm very pleased to see and impressed with the leadership of the Judicial Training Institute and of the court in Thailand to take on these issues in a positive way. I'm going to just share some slides with you, and these will also be available after the session. They'll be provided to all of you. So you can look at these now or review them again afterwards. I'll share my screen now. There we are. So in 2021, the Judicial Integrity Network ASEAN, or JIN ASEAN, as we often call it, started new research on how emerging technologies affect judicial integrity. There are lots of people writing and thinking about technologies, but not that many are examining these technologies from the perspective of judicial integrity. This morning, I will share the results of that research with you. I'll also talk a little bit about some of the key findings and what it means as courts adopt new technologies. And this can, I think, set a context for you as you have more discussions today and tomorrow. First, I'd like to focus on judicial integrity itself. What is that concept and what do we mean when we talk about judicial integrity? Judges are stewards of the individual rights of litigants in their courtrooms, while also acting to protect the broader integrity of the justice system. Judicial integrity is critical to public confidence in the justice system and to the stability of democratic processes, institutions, economic markets, global relations. Having a stable justice system that the public has confidence in is a critical aspect of how we move forward. Judges protect the rights of all of the litigants that come into your courts, as you well know. Judges see how women, children, and vulnerable members of society are excluded or harmed or included in each case. Judges can rectify or redress inequalities both in the individual cases and can bring their perspective about systemic discussions of gender, racial, and other kinds of discrimination into the discussion of the rule of law and the protection of key components of judicial integrity. The perspective of the judge is critical to both how we might change the law, but also how we are changing the way courts operate through technology. very often, I think we don't see that second part of it, where we think about judges' perspectives in the operational changes. We focus more in the changes in the law and the legal expertise, but I think judges have leadership to bring to both contexts. Judicial integrity is more than the requirement that judges behave honestly and conduct themselves properly. Judicial integrity is a multifaceted concept that covers the conduct and practices of judges, as well as the structure and circumstances in which judges work. It encompasses the principles that ensure transparent, effective, and accountable institutions as a critical component of promoting peaceful, just, and inclusive societies and justice for all. Now, the phrase judicial integrity originates from the 1948 Universal Declaration of Human Rights and is a key part of the right that everyone is entitled to full equality in a fair and public hearing by an independent and impartial tribunal. In 1985, the United Nations produced the basic principles on the independence of the judiciary. And then in 2002, the Bangalore Principles of Judicial Conduct set out the ethical principles expected of judges. The Bangalore Principles, and you can see these on the left-hand side of the slide, include 6 values. Independence. Judicial independence is critical to the rule of law and the fundamental guarantee of a fair trial. Impartiality, which is essential to the proper discharge of the judicial office and applies not only to the decision itself, but also to the process by which the decision is made. Integrity, the individual's conduct and proper discharge of the judicial office. Propriety, and the appearance of propriety in all of the activities of the judge. Equality, ensuring equal treatment of all those before the court as an essential way of performing the role of the judge. And competence and diligence, the prerequisites to having the ability to conduct themselves as a judge. All of these values are part of the Bangalore Principles and have been adopted globally as the key components of judicial integrity. Now, judges are also engaged as critical stakeholders in countering corruption, furthering individual countries' commitments to implement UN conventions against corruption and others. And that convention, entered into force in 2005, talks about the judiciary as a critical institution to prevent and counter corruption. So when we think about all of these components, we can see that judicial integrity is both the individual judge's conduct and the way the system is built to ensure that people trust and can access justice without corruption as a factor in the way cases are handled. The implications for these concepts around judicial integrity are very broad, including key aspects of a strong, fair, and rights-respecting justice system. That includes transparency in decision-making, transparency in court administration, the predictability of case timelines, equal access to justice, regardless of status, money, or identity, and equal treatment, regardless of status, money, or identity. Mechanisms to prevent bribery, mechanisms to prevent gendered or identity-based threats, due process, judicial independence, and the separation of the political and judicial roles of institutions. In the context of new technologies, we'll turn now to think about what these aspects of judicial integrity mean. We'll look first here. There we go. At the way we looked first at Jin Asian, at the way that the independence of the judiciary is fundamental to decisions about emerging technologies, because judges must be independent from pressure from the executive, from the media, from other influences, as well as independent of their judicial colleagues. So that independence is both a personal obligation and an institutional one. And when new technologies come in, very often people don't always understand all aspects of that technology. And they, as a result, might leave some questions to court operations that really require a judicial perspective. This is particularly true when we think about equal treatment. As I'm sure you know, the obligation of judges to ensure equal treatment for all persons before the court, litigants, witnesses, victims, experts, requires the integrity of the judge. And that means that the judge must be aware of and understand the diversity of people who come before the court, including the different aspects of race, sex, religion, national origin, disability, marital status, age, sexual orientation, social, economic status, all of the ways in which people's experiences are different. And when people bring conflict to the court, it's the judge's understanding of this difference that is critical to the public trust. They need to trust that they will be treated equally in the courts. Now, you might wonder what this has to do with technology, but I think as we think about how emerging technologies advance or ensure access to justice, judges are one of the few experts who bring this commitment to equality into the conversation about how technologies work. Very often, if we don't have this key judicial perspective, we will focus only on how technologies create efficiencies. And the search for efficiency is not enough. We need to also focus on how technologies advance access to justice and protect the rule of law. And those two areas are the expertise of the judge or the judiciary. The efficiencies and the operations of the technology are often the expertise of the technologist, the administrator, the person who's making decisions at that end. Bringing these two together equally is how we make sure that new technologies only have positive impacts on judicial integrity and on equality for people in front of the court. So just before I dive into specific aspects of these emerging technologies, I want to just ask, make sure we're talking about the same kinds of technologies, or that I create a little bit of a basis here. When we talk about digital court technologies, we often call these e-justice and put them all under the umbrella of e-justice. This includes different kinds of digital technologies, including electronic case management systems, apps and information technologies that people use to communicate with the court, remote and virtual court platforms like Zoom or Teams or other kinds of video technology like we're using today, e-filing, forms that allow people to start their court case by filing online, online dispute resolution, where a whole case happens online, or people submit their evidence and there may even be artificial intelligence that helps to predict the decision. Other kinds of predictive sentencing that analyzes the factors in the case and compares them and suggests a positive or a likely output. The technologies that we use to digitize, store, and provide access to legal documents and to evidence. There are kinds of apps for human rights monitoring that allow people to record their interactions with police, with other authority figures, and upload those to a cloud to provide evidence in those moments. And then there's all kinds of technologies that give people legal information or help them to understand a process. E-justice includes all of these kinds of digital technologies and the process reengineering, automation, data collection, integration of these systems with our analog or in-person ways of working. Now, some of those that I described might sound very much like things that judges need to worry about in the courtroom, and others might sound like lawyers worry about them, maybe not human rights monitoring groups worry about them, but the fact is they all are going to come together in the courtroom if those are the ways that people are learning about the justice system or getting and collecting evidence. So e-justice and digital court technologies need to include both the tools used by the court, by judges, by justice sector professionals, and by the public or the media when they are learning about the court. With that background, let's turn now to looking at some of what happened in the survey and the research that Jin Azian did and the results that we found there. In February of 2021, Jin Azian initiated this research with two inquiry streams that have been combined here to produce this report. And The report itself is public. I will share links at the end of the session, but you can also, I'm sure, find it in other ways through the event organizers. The first is that we looked at a review of academic reporting and sector research about emerging technologies that informed the range of technologies to be considered here today. And you can see here where that data came from, both on issues of emerging technologies and research into the implications for rule of law from all across the globe. Then we moved on to conduct an online survey, and the online survey started to look at the experiences of judges in countries in the ASEAN region. We invited judges to individually share their experience with technologies and how they're being used in the courts, and to reflect on the impact that each of these technologies is having on transparency and accessibility of justice. These individual perspectives provide a pragmatic assessment of the impact of these technologies in specific countries and in different kinds of courtrooms. In some instances, judges from the same court have very different perspectives on whether the technology is helping. And I think this demonstrates some of the challenges of large-scale implementation and the different needs of people hearing these cases. Not everyone comes with the same level of understanding, the same expectation, the same comfort level, and not every case is the same. And so as judges, you will be navigating some of these differences. We are going to talk about 4 different categories of technology, and I'm going to highlight each one of these briefly, including some of the results that we saw from the survey. And then I will turn to what that means for moving forward for your courts, as well as for learning the way that courts across the ASEAN region are moving forward. So first, we are going to look at issues about e-forms and online filing. Online fillable forms are forms that are designed to make it easier to submit, find, and use court forms. Now, some courts use e-filing functions that allow people to create a PDF that they submit. Others are interactive and actually let people upload evidence, upload a link to different kinds of documents. So there's all different levels of sophistication. We saw that people really relied on these forms during lockdown phases of the pandemic, when it was impossible to either visit a courthouse or perhaps to get the form or to bring it back to the courthouse to file it. Courts with e-filing were able to maintain continuity of those services. Typically with e-filing or online fillable forms, people can submit those forms directly. They also can update those documents. And that might be important in something like a divorce or a child custody case, where financial records need to be provided each year, or updated information about healthcare decisions around a child can be updated even after the case has started. E-filing also is very helpful in cases like making a complaint about a landlord or dealing with matters where each of the parties will have multiple documents that need to be shared with each other. Online and e-filing mechanisms allow those often to be shared automatically. Now, I'm going to take a look here at what we heard when we surveyed judges and court administrators in the region. And we saw that 64% of judges had some experience with e-filing as a way of submitting forms. Some similarly with arguments being able to be submitted by lawyers, and then less so as we go down the list here of whether people could submit evidence directly, whether experts could submit evidence electronically, and whether the police could submit evidence electronically. So we see some variation here in how that works when we turn to the application of it. The second category of technology that I'm going to focus on here is electronic case management. And this is often related in that the form is initially submitted, but then what happens after that? In cases of sophisticated electronic case management, we see that this replaces the paper-based aspect of the case file. And instead of there being a paper-based file, there is instead a single electronic file created in a secure environment with differential access for court clerks, registrars, judges, lawyers sometimes, and that is stored securely in the court archives, separate from government files, separate from ministries of justice. Now, digital or electronic case management also automates many aspects of the court case process. Documents can be automatically shared back and forth between the parties. Scheduling can be simpler, automated without people having to come to court to talk about when they're available. Even decision-making can be sped up through the digital case management process, and it can be linked to enforcement and monitoring aspects. This allows to both better quality management of the files with less errors. There are less people filling in the paper, less likely to make a mistake in the spelling of a name or a birth date, less likely to have duplicates of files. It also helps to protect against corruption. Very often in a digital case management system, there is an anticipated case processing time, and cases that are taking longer than expected for that type of case can be flagged. Once they're flagged, perhaps there's a good reason for the delay, and that's obvious, or perhaps that flagging of the case helps to identify places where there has been corruption at some point in the process, in the provision of documents, in the way it's worked through a clerk process. And that flagging of those cases helps to identify and address those points, eliminate those points for future corruption. Digital case management is also valuable because it helps to secure from natural disasters like fire or flood, because those case files can be securely backed up and moved for greater stability of property and financial decisions. And we certainly saw during the pandemic that cases that were done through a digital case file completely were easier for judges and lawyers to maintain and continue through a process of virtual cases or of managing a case from home. If we look now to what we found out when we talked to judges in the ASEAN region, we saw that 74% of respondents use some form of electronic case management, but it often was just for some of the basics of it and not for the full sophisticated aspects of digital case management. Those were yet to come. Looking at the pie chart at the bottom, you can see that for most people, they found it very easy or neutral to work with a digital case management system. Only 13% described it as difficult or very difficult. So we see a real appetite and comfort amongst judges in using this technology. I'm going to turn now to the third of the technologies that we're going to look at today, and that is virtual or online hearings. Now, virtual hearings, I think we are all much more comfortable with now because we've been doing so many of them, but they really were not that common at the beginning of the pandemic. And so we've had a lot of evolution of people's familiarity and comfort in this kind of environment, but we are still dealing with little glitches and difficulties. So a virtual or an online hearing, as you can see here on this slide, includes either hearings held by video, like we are doing today. It can also include court hearings that are conducted completely by phone. In either case, either nobody has to attend the court in person, or some people don't have to attend the court in person. Often an expert witness who might be appearing from a different region or even a different country. You might have a victim, particularly a victim of sexual abuse or child abuse, by protecting their experience, not making them appear in person. Other times, it's much more about dealing with something like public lockdowns and using this technology to address gaps that might have in the consistency of court operations otherwise. Now, if we look at what happened when we talked to judges in the region, we see that 69% of judges had some experience using virtual appearances for lawyers. Only 41 or 42% were used to having the public or the parties or the expert witnesses participate. So what we see there is that meant when doing scheduling, appellate matters, things that just involve lawyers, people were using technologies, but when it involved the public or the witnesses, less so. And when we asked judges whether or not how that was affecting the speed of trial, people all thought it was making them faster. Only a very few people thought that technology slowed things down. I'm going to turn now to the last of my 4 categories of technology, and that is artificial intelligence. And I think this is often the most controversial of the categories, in part because it's the hardest to understand. You know, artificial intelligence is an umbrella term that it gets used for a very wide range of methods and tools. Machine learning, facial recognition, natural language processing, algorithms, predictive decision-making. These are all aspects of artificial intelligence. In the court process, artificial intelligence might be used to analyze patterns in cases, to provide judges with options for sentencing to align with similar cases. It can be used, as I mentioned earlier, to track the progress of a case, to identify cases that might not be progressing at the same case. And in fact, one example is in Brazil, where artificial intelligence is being used to flag cases that fit a pattern of domestic or intimate partner violence to speed up the process for those cases where women and children might be at risk of violence in their home, to make sure that those cases dealing with a risk of violence are dealt with quickly. And so that's an interesting use of artificial intelligence to help the judge to make sure that people all get the equal benefit of the law. These uses of artificial intelligence all use a combination of machine learning and a human decision maker. And I think sometimes when we talk about artificial intelligence and judging, people picture replacing the judge with an algorithm. But I don't think that's what we're talking about for the most part in courts. We're really looking at artificial intelligence helping the judge by bringing in a faster way that analysis to their decision making, but still having that judge as the human decision maker who can strike a balance between the analysis done by the algorithm and the importance of judicial discretion and empathy that they bring to the process. When we talk to judges about artificial intelligence, they overwhelmingly cited the faster trial process and the consistency in decisions as primary benefits or advantages for both the public and the justice system. They also saw that there was a potential for artificial intelligence to protect judges from allegations of bias, because the public can see that this analysis is happening, and that means the judge might not be accused of being biased. It also can really achieve greater efficiency, and that can help to address backlogs. So artificial intelligence, as seen by judges, can improve transparency, fairness, and public access. However, we also know that when it's not done carefully, artificial intelligence can actually embed biases, because if we train the machine on decisions that have embedded biases, we will replicate those biases in the algorithm. And there is a real concern about losing that human touch to judging. We know that cases are complicated and people's situations are difficult. And when the judge listens to everybody and factors that in, they can bring that empathy and compassion to the case. That is lost if we move too far to the other side and are only watching the algorithm and paying attention to that analysis. So some balance is really needed when we explore these kinds of emerging technologies. Now, thinking about what judges in the ASEAN region thought about this issue, we saw that 7% of people have been using predictive technologies in their courtrooms. 17% had been using them as a research tool, and 14% had used pre-populated decisions that look at similar cases and then suggest a possible decision with a machine learning component as a template, and then the judge sort of chooses from amongst that template. Alarmingly though, and you can see from this screen, 68% did not receive any or enough information about the process of how the algorithm was trained, and only 4 respondents felt that they had confidence in what that algorithm was based on. So everybody else was worried that the algorithm itself might be based on the wrong kind of information or be replicating bias in some way. And I think that's an important stat for us all to remember as we now move on to talk a little bit about what this means and how we move forward for judges, what kind of tools to use. Because we can see from this last slide that the judicial leadership was not a part of the design of these systems if judges did not feel like they had enough information to understand and trust that system. So what does this mean in terms of findings? We see first here in terms of court transparency that the new technologies are improving access for the media, creating more transparency, making it easier for the media to report on and share directly the comments of the judge. It's also increasing the transparency of the hearing process itself. It's easier for people affected by a case to log on and watch the case than it is to get to the courthouse. And that's creating opportunities for people to understand the decisions affecting them, to see the proceedings directly rather than relying on second or third hand versions of what's happening in the court. Now, turning to think about the findings from the perspective of access to justice, the judges in the ASEAN region who completed this survey found that the new technologies are making the court process more accessible for most people or for everybody. However, as we can see from the bottom 2 images, economic status remains a barrier to people using these technologies. Not everyone has enough internet access, enough data, computers or smartphones that allow them to access these technologies. So there is still an economic barrier. Some rural places don't have sufficient bandwidth or internet reliability, or even sometimes electricity at a reliable level for this kind of complex matter. And then secondly, we can see that education level can be a barrier. And so if we want to move forward with emerging technologies, it's important to remember that we also need to meet the needs of everybody, even those who are most vulnerable. The implications for vulnerable groups are really mixed. For example, technology holds great promise for people with disabilities. It allows ways for people with disabilities to communicate directly with the judge without having to rely on someone else to read their documents out loud or to speak on their behalf. However, for the elderly, technologies are often unfamiliar or even intimidating, and they might find that they just don't want to participate in a process if it happens through technology, and they're much more comfortable or familiar with doing that in a setting where they speak directly to a person in the courtroom. I'm just trying to move a little bit because the sun is changing on me and I can see that it makes it harder for you to see me. So we'll see if that helps. So in face-to-face trials, we often end up with people like the elderly having a more comfortable experience when they're in person and they can talk to the judge directly. Another example of how technology helps vulnerable people is when we talk about women or children facing violence, and the fact that they can testify from a remote location is great for their safety, but it might make it more difficult for the judge to be certain that they aren't being threatened or coerced by someone else in the room. So all of these factors are really important when we think about how technology affects access to justice. Technology doesn't solve all the issues. And as one judge said in our survey, in face-to-face trials, they have no money to go to court. In virtual trials, they have no money to access cell phones and they don't have the technical know-how. We still need to think about access to justice for everyone. Moving completely to a technology-based system will not solve all of our problems. We need to continue to develop both technological solutions and provide use the time and money we've saved with those new efficient systems to be able to give greater attention to those who are being left behind, to those who are most vulnerable. Now, I want to just share a couple of the concerns that judges shared with us as we talked about these technologies in this survey. So we can see here they were concerned about gender equality in emerging technologies. They're concerned about bias in artificial intelligence, privacy concerns, the security of the data. Who has access to the data? Is it secure from hacking? Is it secure from government interference? This idea of court versus government control of the files. And I think that's very important when we remember that the government is involved in every criminal case, in lots of cases that they are actually a party to the case. And so it's important for the public to trust the judicial process, to know that the courts and judges' files are kept separate from government files. Private ownership of technology is a concern that many judges raise, as well as making sure that judges can continue to bring discretion to their job, that they can listen to people and pay attention to the facts of the case. So out of all of this research, we made 9 recommendations about how judges can use their position of leadership, either in the courtroom or within the planning and administration of new technologies themselves, to promote judicial integrity, rule of law, and access to justice. So you can see here, and I'll just read each one out. The recommendations are that judges can ask questions about the data being used to train algorithms and artificial intelligence. Is it the most reliable data? Do judges think it's the most up-to-date and comprehensive? Judges and judiciaries can identify gender, racial, and identity-based bias in the machine learning or algorithm process. They can ask for briefings about how the artificial intelligence systems are being used. Turning to what's happening in the courtroom itself, judges can talk to litigants and witnesses about the virtual court process, about the kind of decorum that we expect online and how that's different from in person, and about how the technology is being used. And in fact, judges might notice that someone doesn't seem to be able to participate sufficiently and can stop the process and make sure that technology is not a barrier to their full participation. In the planning of new technologies, judges and judiciaries can raise the rule of law and trial fairness criteria right in the planning and make sure that trial fairness is not being sacrificed in the name of efficiency. Because we want the efficiencies of new technologies, but only when they continue to support the fundamental principles of trial fairness and rule of law. Judges can also really scrutinize the kind of evidence and witness testimony that comes through virtual courts and other kinds of technology to make sure that they have the same level of trust they might have had from the things they saw in person. The judiciary can also promote understanding of the court processes with litigants and witnesses who might be confused by what's happening in virtual environments. And that might be as simple as explaining how the processes will be conducted online, or making sure that the way the role of the judge is described is similar to what people expected when they were coming in person. Judiciaries can also support, and judges can support each other to build the skills and understandings of new technologies. And this conference is a great example of that. How do we learn from each other? How do we make sure everyone has the same basis in vocabulary, in understanding the technologies, and in understanding the rule of law criteria? And I think, as we all know, in the context of judicial integrity, continue to pay rigorous attention to avenues for corruption, because they certainly exist in technology-based environments as much as they do in person, and we need to continue to bring a rigorous view to that. Now, out of this research and those recommendations, Jin Asian created a number of tools, and I will share the links to these tools at the end of the session. They are tools that are available to anybody, a judiciary as a whole, an individual judge, to bring their understanding of a specific technology up a little bit, to learn what new vocabulary means, or if being asked to participate in the design of a new technology or a new process, a checklist of key access to justice questions, key rule of law questions to ask when thinking about data security, privacy, artificial intelligence. So these tools are really designed to help anybody who is looking to participate in the process of planning for and expanding the way that courts are administered through technologies. These, I will share the links to these at the end, and I'll also put them in the chat. Now, having thought a little bit about what we learned in the region, we really wanted to turn then to think about, what does this mean next? What does it mean going forward for judges and for judiciaries? And giving the complexity of these issues a strong understanding of the rights implications of judicial integrity is critical. However, many judges find they can't get enough information about the data security, about who owns or can access the data, about the continuity of evidence, or even the safety of a testifying witness. Many judges don't understand the technology well enough to ask the right question. And so, as we saw in the survey, they might just say, I hope someone's looking after it, but I don't know how to ask that question. And this is no surprise. Changing technology is a challenge for many professionals, not just judges, of course. Lawyers, academics, public servants, judges are no different. The difference here, in my opinion, is that the judicial role is unique. Judges must not only have confidence in tech-based solutions, but they must be able to convey that confidence to the public. They must help the public to have the same confidence that the high standards of court operations and adherence to the rule of law are being met even through these new technologies. And the public looks to judges to reassure them that these obligations are met, that this process will protect against rights violations and ensure equality. And so, one of the interesting insights out of the research is the need for and the value of judges participating in the design and planning of new technologies in order to bring this expertise in human rights, in individual rights, and in the rule of law. There is no question that that expertise comes all the time when we talk about the rules of court or different kinds of changes in the law. But often in the planning of a technology upgrade, the only question asked to the judge is about how they themselves might want to use the technology, rather than also asking questions about how that technology affects everyone who comes into the courtroom. The operational and administrative decision makers don't always reach out to judges to proactively engage around these other kinds of parameters. And this leaves many judges in the dark, kind of hoping that someone with more understanding than them has already asked the right questions. Other situations, we see judges see the rights violation after the technology has been introduced. And then they try to use their case management responsibilities or their control of their own courtroom to put some protections in place. And while this is a good solution in that specific case, it can often appear to people that the judges are resisting the technologies or resisting using tools that bring access to justice benefits to others, when really we know that those judges are worried about the implications of technology in their courtroom. To deal with all of these problems, I think it's critical that the judiciary is well supported to bring engaged leadership as an opportunity to bring their rights respecting expertise into the design of court technology, rather than waiting until after it's been raised and trying to find a fix or a workaround. So that takes me finally to our next steps. We need to collectively support judges involved in the evolution of courts across the sector to bring that judicial leadership into the conversation about technology. And many judges are wanting to do that. Others are looking for help to understand the technologies first. That's particularly important as we recognize that local or regional lockdowns are likely a permanent reality. We will be dealing with different kinds of lockdowns, whether natural disaster, climate change, health lockdowns, all kinds of things. we are going to need our courts to be more agile, more flexible than we used to have. We need careful, scrutinized decisions about the long-term use of technologies. And the work that's being done in the ASEAN region is a really good start. A related part of Jin ASEAN's research also looked at the issue of gender equality in the courts. And I just want to take a moment before I conclude to talk about how we saw evidence there of the way judges are using technology to address gender equality. We often kind of speculate about how a judge will deal with an argument of gender equality, but we rarely think about how the issues of gender equality play out in the courtroom itself. Now, data shows that sextortion or extortion and corruption based on sex, that's the suggestion, the request of sexual attention or sexual favor in exchange for getting a document, moving something faster through the process, is rampant in the region and frankly in much of the world. This isn't an ASEAN region problem, it's everywhere. People are being pressured to exchange sex or sexual attention for basic services like school registration or healthcare, and it's predominantly women who are being extorted. Collectively, we need to pay attention to this problem. Lawyers need to pay attention, public officials and judges. And so when there is a suggestion of or evidence of sextortion, we need to take that as seriously as other forms of corruption, to see the laws that address extortion being used, to see the laws that address corruption being used just as often to address sextortion when it happens both outside of the court in the facts that come and when it happens within the court process. And technologies are offering new strategies to track and respond to gendered corruption. In Indonesia, a whistleblower platform is being updated currently with Jin ASEAN support to include avenues for reporting sextortion and for creating aggregated data based on gender to help judiciaries and individual judges understand who is most vulnerable. And that will make it easier for judges to see the patterns of corruption and specifically scrutinize the evidence that is brought before the court. These efforts are part of the building up of public confidence in the justice system to ensure that judges are actively protecting everyone's rights and ensuring equality and promoting the rule of law. Judges are in a position, of course, to call out discrimination within their courts, and they observe the treatment that lawyers and court staff give to all of the people in the courtroom, experts, witnesses, the arguments made by counsel. It's a part of the judge's job in promoting judicial integrity to make sure that the highest standards of equal treatment for everyone in the court process is maintained. And that's another one of the ways in which judges cultivate confidence in the justice system and refute that public perception that the system favors those with privilege. Instead, it meaningfully calls out discrimination at every level. So when we think about e-justice as an infrastructure project left to technologists and administrators of courts, we really miss the chance to bring judicial leadership to ensure a rights-respecting, people-centered approach. But e-justice or digital transformation is not just changes in how we do justice, it's also a tool for transforming and really improving access to justice. It can be strategically employed to advance the evolution of the courts, but only if those with the rights-based expertise are a part of that process. When we miss that opportunity, we see more of the negative implications and less of the positive ones. There is no simple answer to whether technology will be always positive or will undermine privacy or will it increase access to justice or strengthen the rule of law. Instead, we need to be recognizing that technology is the way forward. And how do we scrutinize each implication? How do we look at each use of technology from multiple perspectives, not just from that of efficiency, in order to move that forward? And at this point, I'm going to just share on my screen a last slide that has the links on it if you'd like them. I'm also going to put them in the chat, and while they're up there, we have a few minutes for questions. I know I've covered a lot today, and so if there is anything that you have questions about? I'm happy to take a few questions in our last 7 or 8 minutes here. I will be relying on your interpreters if you want to ask your question in whichever language, and they'll repeat it to me in English.
ครับครับสวัสดีครับทุกท่านก็เป็นการบรรยายจบแล้วนะครับแต่ว่า
So the presentation is finished, but now it is we have about 10 minutes for question and answers. And for you can also ask other things apart from technology, because Ms. Sarah has the worldwide experience, so you can actually turn on your microphone and speak.
I got one question. Thank you for sharing such a really useful information about digital transformation. I really appreciate it. But one thing I got one question. One thing I learned from working on the transformation related thing is that human in the organization is a huge barrier for the transformation process. Some even said that before we are working on the digital transformation, we have to transform our mindset of the people in organization. So do you have any recommendation on that? Because this is a huge problem that the court have already, we are facing this kind of problem. Do you have any recommendation on that?
You raise a very good point. When we talk about digital transformation, sometimes we picture computers and programming and code, and we think it's all very technical. But like every other change, it is mostly about changing behavior and changing attitudes. It is about how we use technology and if we feel comfortable with it. And many people resist something that they don't understand, whether that's the judge or the public or the witness or the court clerk, everybody. When we don't understand it, or when we think it's going to be more work, we resist it. When we start to see the advantages to it, that's a motivation to learn. And so I think conferences like this and any point where judges share their experience is one of the key ways to address that shift in behavior, because judges hearing directly from each other about how it worked is going to be much more reliable information about what the future looks like than simply imagining the worst case scenario. Really connecting individuals to learn about that process. The other thing I think we've seen, and the pandemic was good for this, is it sped up that process. There were many people who said courts will never be online. We never need to do that. We will always be in person. And then all of a sudden, no one could meet in person, and lots of people who resisted that idea started to find workarounds and were pleasantly surprised to see that it worked. And so I think one of the strategies about introducing technology is to start small and manageable, maybe with one court, one location, and really do a good job of collecting data and sharing successes, putting examples of that success up online, sharing them with other judges, and tracking what's working. Starting with a technology that rolls out everywhere in the country all at once is going to have glitches. It's going to have little mistakes at the beginning. And if that's people's first experience, they'll be quick to resist that technology. But if instead we start small, experiment a little bit, worry about and maybe solve some of the early problems, and then start to roll it out, people start to see the potential in the data about why it's working. There is lots of that data on small scales on projects that are happening around the world. And as was just mentioned, I have been working with UNDP on a global map of e-justice projects, where it's possible to see who is working on similar projects anywhere in the world that are focusing on rule of law, to learn those early stages and to share that upfront. I'm sure most of you who are joining here today are already interested in emerging technologies. You're probably not the ones who are resisting the change. You're the ones who are interested in doing it. But anyone who works on changing patterns and changing attitudes will say that people need to hear about change a few times before they dive in. They need a chance to get used to it. And you are all probably the early adopters. Sharing your experiences with your colleagues will help to bring them along. hopefully that gives you a few ideas on your questions. I don't know if there's any other questions I'm happy to address. Yeah.
Thank you, Sarah. We appreciate it.
My pleasure.
ท่านอื่นถ้าเกิดมีคำถามสามารถสอบถามได้นะครับเรายังพอมี
Other people, do you have any questions? We still have a few minutes before we go to the next session.
ครับก็น่าจะไม่มีคำถามเพิ่มเติมก็
Just one more question.
ครับเชิญเลยครับ
Sorry, my question is a more simpler one than the previous questions. Previously, when we want to take testimony of witnesses from abroad, usually we use, for example, some treaty or agreement between countries, and probably ask the court in other country to conduct the testimony and probably carry it out via video conference or something like that. But now we can conduct such kind of taking of witnesses directly by Zoom or by any other applications. How are the views of the court in other country when, for example, a Thai court conduct a hearing remotely by Zoom, and the witnesses are in other countries, for example, from the US, from the UK? How the courts in other countries view this kind of means of taking of evidence? Does they perceive the action as the infringement of their jurisdiction or something like that? Or they feel free for us to do that?
You know, I think questions of jurisdiction really focus on what the legal matter is. So if the legal matter is a matter that is based in Thailand about Thai law, I don't think other courts feel that there's any jurisdictional issue just because the witnesses happen to be in a different country at the time that they are testifying. It's really about the core of the legal issue. And is that legal issue one of a violation or a breach that happened in Thailand? Of course, where this gets complicated, I think, is with complex commercial matters where the parties are entities that exist in different places, and there's often an argument about what the appropriate jurisdiction for a legal matter would be. However, very often expert witnesses, the experts on issues, especially issues around technology, around global trade, are going to be in other countries. And it's a greater concern to the legitimacy of the decision if that perspective is not heard or not factored in than it is if we only listen to witnesses who are within the geographic bounds of the country. So what I have seen in talking to other courts is courts are very open to and don't see any concerns with using technology to allow witnesses to testify across borders, especially expert witnesses, or perhaps witnesses who are vulnerable in various ways. Witnesses who have fled from violence, who are now in a safe place in some way. Where I think there will be a concern is when video conferencing is used to try to stretch the jurisdiction. And especially if, say, a corporation tries to look at all of the legal frameworks and decide in advance which country's laws look the most favorable, and then try to pursue their legal matter only in that country because of differences in the law. And I think that would be something that is of concern to all judiciaries, you know, Thai and other places. And there's starting to be a little bit of conversation about that, but I don't think it's the testifying of witnesses that is the real concern as much as sort of the judicial shopping around of those court cases. All of the courts that I talked to that have adopted virtual hearing models before the pandemic hit, use them frequently to allow people to testify from other countries. And we're very open to that possibility. So I've talked about sort of a couple of issues. Did you have a follow-up question there as I?
Thank you very much. I think your answer is quite clear because during the pandemic, we have some discussion whether it is okay for the court in Thailand to conduct a hearing when the witnesses is abroad in other country. So if the perception of other court in other country is okay with this kind of practice, I think for our law, there is no specific prohibition as well.
Yeah.
Thank you very much for your answer.
I do think you raise an interesting point, though, and judges especially to begin with, often wanted to ask a few more questions about where people were, about how to verify identity, some of those kinds of things, and there are all kinds of ways to work around that, and there are good models for how to do it. In cases like domestic violence, often the judge asks the witness to hold up their camera and show the whole room to make sure there's no one else in the room. There are those kinds of strategies to help the judge feel confident that the person testifying is who they say they are and that they're not being influenced. And there are starting to be sort of guidebooks for judges. I know the National Center for State Courts in the US has been promoting one for all of their judges to encourage these exact kinds of practices for different kinds of court cases. It's an important question to keep thinking about, though. I don't know whether there's time for another.
So now we've run out of time for this session. So if any judges or participants have further questions, you can send them in the chat, and we will then we will find the answers from Kun Sarah. I think this session is a beginning session and an overall information where, and we will pursue each topics and in depth later on. So so this is just the beginning. So in this session, I'd like to thank Ms. Sarah McCubry, who the experts on the Court of Justice, who has been working in the ASEAN countries as well as other countries. And we hope in the future we will have her invited to come and exchange her experience with us again. Now I would like the Judicial Training Institute to lead the next session. Thank you, Kun Visut. Next is the discussion on the judicial plan for digital transformation. And we are honored to have three resource persons here. The first person is Assistant Professor Supat Vichai-Chod, the Deputy President of Kasetsat University, Sriracha campus. Good morning, everyone. You can hear me well, okay? I just want to give an overview on the digital transformation plan, and I will use about 1 hour. Can I share the slides? Okay. So here is the Court of Justice Digital Development Plan of 2022 to 25. So if you have any questions, you can raise it right away because I've got quite a lot of content. I will start with the concept, the background of this plan before going into the content of the plan. May I introduce our team? We are the consultant team from Kasetsat University, Sriracha campus. There are about 10 people in the team, and I am the project director. And so we have 3 ICT experts, and we have others involved in experts in management. Let's just again ensure the meaning of digital transformation. This is a reference to the Professor Achara. The digital technology is more than just buying IT equipment to enhance the capacity of the organization. It's basically to adopt and apply the digital technology for the whole operation in order to build strategic advantages and then strategic opportunities. These are 2 terms also appear in the plan. So basically, the purpose is to build users experience, which is a popular term. So this is the overall meaning of digital transformation. So this plan has been developed under this concept. In terms of the goals for this 4-year digital transformation, we have divided into digitization and digitalization. As you know, digitization is a transforming the analog to digital system, but digitalization is the adoption of technology to build new models in order and to increase the values and benefits for the users. So we need to empower the staff and also to engage customers in order to transform the core services to facilitate its use by the users. If one one citizen wants to access the services of the court, they might be able to have to go to go there. And we are hoping the goal is to ensure that all the court services are organized as a kind of a one-stop one-stop platform. And these will be the applications that can be downloaded in different devices so that the users can access anytime. For example, in services in terms of traffic law, so we want to aim for personalized services for everyone. So let's look at the business model. We try to bring the business concepts as well to be applied in this plan. So we try to, once we complete the plan, the products and services of the court should be entering level 3, that is platform businesses, the platforms that I mentioned earlier, the one-stop platform. The level 4 ecosystem platform or mega platform is a platform where all the businesses of the others apart from outside the court to here. So we should be entering the mega platform. The processes for devising these strategies are based on the international principles. We've set the core values, vision and mission, and this is the workflow, and we've adopted different various frameworks so we use EA or enterprise architecture in doing internal analysis. We use PESTEL to analyze the external factors, and we use SWOT, executive survey, customer survey, and then the balanced scorecard or BSC to generate this plan. For balanced scorecards, it will come out with the strategic priorities, and I will touch on that later. Next, we also determine strategic objectives, and then to build strategy maps to ensure that the strategic objectives are linked between cause and effect. And there are also, we did identify measures and targets and initiatives. Initiatives are like projects that have never been carried out before. This plan is going to lead us into the future. So most initiatives will be something that have never been implemented before. And we've done the cascading in step 4, and based on the idea that the digital plan is the plan of the courts and the whole court system all over the country. So the tools, we use the balanced scorecard that people may be familiar with. There are 3 balanced perspectives, and there's a belief that if there are people who are good at learning and growing, it will enhance the internal process to become more effective. And with the good personnel and good internal process, then the customer should be satisfied. There should be customer satisfaction. And that means there would be more financial return. But we are not going to talk about financial return here. This is just a picture of the key principles of the balanced scorecard. And so after the balanced scorecard application, and we set strategic priorities. And these are strategic priorities of an organization that is for profit. That's why they put financial return at the top, because that's the shareholders' value. Right? But we are government agency, so we look at the stakeholders at the top, that benefits to the stakeholders. So all the stakeholders in the court ecosystem, these are the stakeholders. So the perspective of the stakeholders are placed at the top, and below that, on the right, is the internal process. And then the orange one is the learning perspectives, and the financial return is actually at the bottom. These are strategic priorities for non-profit organizations on the right, I mean. And here is the roadmap. We use the concept of the public reform office for the 5 dimensions. The digital one is digital literacy. The second dimension is digital governance, standards and compliance. Then the third one is digital technology, digital process and service design and assurance. The fourth one is project and strategic management, digital leadership. And the fifth one at the bottom is digital transformation. So these are a part of components of our roadmap. Then we look, we linked to the other considerations. The public organization, public agencies are actually entering the PMQA 4.0. PMQA 4.0 is aimed to become high performance organizations. So we frame the digital plan, our digitalization plan to push for the court to achieve high performance organizations too. That is in line with all the high performance government agencies. So this PMQA 4.0 model, but there are different models for different academic institutions like us. And we also, for secondary schools, is called OBEC-QE. These are models that have been based on the US Excellence Framework, Malcolm Mobic something. And basically we rely on international global models to lead us to become high performance organizations. The high performance organizations will work on developing 4 aspects: structure, process, and using the digital infrastructure, digital technology infrastructure. Then for people, that is people development. So that will be, for us, it will be in the digital area in the main. And the culture is the digital core value. So we are focusing these in the digital technology way. So the core values is the soft power that will propel our staff and personnel to be ready for new initiatives that has never been carried out before. So this HPO will enable the courts to transform from being good organizations to great organizations. This is the cycle for excellent organizations, great organizations. The customers here are the public who use our services. So the vision, mission, and values actually are based on the needs of the customers or the users, the services users. So what the court has to do further than this is to plan their improvement, developing the personnel, and do some monitoring evaluation, and then deliver the services to the people. And then getting feedback from the people who use the service. And then using these feedbacks as well as the desire of the customers to adapt and improve the system. And that will be a kind of revolving plan. So we have completed the strategic plans, and what's remained is for the courts to be implementing the strategies in order to become high performance organizations. So we have prepared the roadmaps using all the data that I mentioned under the public organization reform kind of roadmap, and then considering the needs and desires of all the stakeholders. So here is the roadmap that within 2022, what will happen, 2023. I'm sorry, I've just recovered from a flu. So here are the plan for the 4 years. And so once in 2025, we should able to enter the high performance organizations. So these are the digital transformation roadmap that will be used for planning for strategic transformation, in order to ensure that the strategic plan so to align with the national plan. So we are doing we're now conducting this alignment. So we have adopted the main strategic plan, the overall strategic plan, and then to put into this chart. From our analysis, we found that the court has not considered the financial aspects. So, but has the stakeholders perspective, and then the process perspective, and the learning and growth perspective. These gray boxes are the strategies, the core strategies, and these pink ones are what we assume will be embedded into the Court of Justice plan. From all our data gathering, we say that the vision is to do digital transformation involving 4 keywords. That is online platform to facilitate use by the service users, and also to so users should be able to access personalized services. For example, the way we use Facebook at the moment. So that will be the first keyword. And the second keyword is for a paperless process from the beginning, and where data can be accessed on all devices. So, and also the service users will be able to access or provide information to the courts, and once that will cover everything. And then the last one is security. And so our mission now also includes 4 aspects. One is to adjust the paradigm, and to develop knowledge and digital knowledge and skills. These were the 4 missions. Once we've got the missions, then we look at the strategic objectives. According to the balanced scorecards. So these strategic objectives divided into the 4 areas of balanced scorecards. Then the this one is the trust, the SO or strategic objective should be able to be linked to the main strategy of the court. In terms of from the stakeholders' point of view, there are S1 to S4, and for internal process is P1 to P3, and then learning and growth is L1 to L3, and then financial return is the F1. There are 11 strategic objectives that are in line with the roadmap of the public reform committee. So this is a rechecking. All the 11 strategic objectives we try to illustrate with one chart. Like Einstein said, if you cannot explain what is difficult in one picture, then that means you don't actually know the stuff. So that's why we rechecked the understanding and all the strategic objectives to show them in one chart here. From the 11 strategic objectives that comes from balanced scorecards, we look at F1 is like how to use the budget effectively, because the budget comes from the people's taxes. So we have to make sure that we use it effectively. And F1 here is the basis for all. And so we find that if we can do the structural digital transformation, we should be able to build the core values, digital core values, and which will become the organization's culture. And as I said, there will be a lot of changes when we implement this digitalization plan. If we don't prepare the personnel and the values of the personnel, then we will not be successful. So the values of people's personal values and if we can change the personal values, then we will be able to develop the digitalization process much more effectively. That means the core values among the personnel of the court are the key. So also the L2 will support the S4, that is that is providing the services to the stakeholders, customer satisfaction, and we link our strategies and the vision to the data. So we could develop the infrastructure, our infrastructure, to respond to our strategies about what database, what applications have to be used. This will be answered by P3. And then P2 is modernizing the digital infrastructure. And if we build the digital skills and develop the digital infrastructure, then we can develop the big data to provide services to the stakeholders efficiently. Once we've modernized the infrastructure, then we could build the trust and the credibility among the public. On the left side, how we link the digital skills of the personnel in providing the services to the stakeholders, And also we go to S2 at the top, that is providing innovation services. If we have big data and credible data, we will be ready to provide the services through the digital platforms, and then the court will enter the new model. Before we get to the model number 4, that is mega platform. So that is this is the strategy map. And also there will be a cause and effect too. So we see this balance scorecard, and there are indicators for strategic objectives. These indicators for each strategic objectives, maybe there are 2 indicators, and this is the indicators at the level of strategic plan, that is SKTI. So we will measure the output and outcome, but not the process.
มันเราพยายามจะวัดสิ่งที่เป็น outcome ก่อนเช่นความพึงพอใจของผู้ใช้บริการอย่างนี้เป็นต้นนะครับเราก็มีการกำหนดตัวค่าเป้าหมายในแต่ละปีไปด้วยนะครับเหมือนที่ทุกท่านเห็นแล้วก็มีการกำหนดโครงการริเริ่มส่วนใหญ่โครงการริเริ่มจะเป็น1:1ของวัตถุประสงค์เชิงกลยุทธ์แต่จะมีวัตถุประสงค์เชิงกลยุทธ์บางกลยุทธ์นะครับที่อาจจะมีโครงการริเริ่มมากกว่า1โครงการเพื่อคุมไม่ให้โครงการริเริ่มเนี่ยมันมากเกินไปเพราะโครงการริเริ่มคือสิ่งใหม่ที่ศาลยังไม่เคยทำมาก่อนส่วนใหญ่จะเป็นอย่างนั้นนะครับส่วนรายละเอียดของโครงการริเริ่มเนี่ยเดี๋ยวผมจะนำเรียนทุกท่านต่อไปนะครับเราก็จะมีโครงการริเริ่มประมาณสัก12หรือ13โครงการริเริ่มนะครับทีนี้ผมจะขออนุญาตชวนทุกท่านมาดู F1 นะครับ F1 เนี่ยจะเป็นโครงการที่เราไปชี้วัดในปี68คือเหมือนที่ผมนำเรียนทุกท่านว่าตัวชี้วัดที่เป็น strategic KPI ที่ทุกท่านเห็นในหน้านี้นะครับเราพยายามวัดยกระดับการวัดจาก process KPI output KPI มาเป็น outcome KPI คือการไปวัดที่ลูกค้าแต่ outcome KPI ที่ทุกท่านเห็นในหน้านี้มันก็ยังไม่ใช่ที่สุดของ KPI นะครับเราพยายามที่จะให้แผนดิจิตอลในยุคต่อไปของศาลนะครับ4 ปีต่อไปนะครับเข้าสู่การวัดที่เป็นตัว impact KPI นั่นคือเราก็เลยจะมีตัวชี้วัดว่าร้อยละโครงการต้นแบบที่มีความคุ้มค่าในการลงทุนจะมีการวัดว่าศาลลงทุนไปกับโครงการเรื่องดิจิตอลตัวนี้1 ล้านบาทสุดท้ายแล้วประชาชนเนี่ยจะลดค่าใช้จ่ายของเขารวมกันได้กี่ล้านบาทสิ่งนี้เรียกว่า social return on investment SROI เดี๋ยวผมนำเรียนต่อไปนะครับนี่คือสิ่งที่เราจะผลักดันให้ใช้ SROI ในการวัด impact KPI ของศาลในยุคต่อไปซึ่งมันต้องมีการเตรียมตัวนะครับเราอาจจะยังทำไม่ทันในแผนปีนี้แต่วางกรอบเอาไว้ในรอบ4 ปีถัดไปแล้วนะครับเพราะฉะนั้นในรอบ4 ปีถัดไปทุกท่านจะเห็นตัวชี้วัดของศาลที่เป็นตัวชี้วัดด้าน impact มากขึ้นกว่านี้นะครับผมไปต่อนะครับพอเรามีการกำหนดตัว strategic objective แล้วเนี่ยนะครับที่มีอยู่11ตัวเนี่ยนะครับเราก็มีการไปรีเช็คอีกรอบนึงสอดคล้องกับแผนของประเทศกฎหมายของประเทศยุทธศาสตร์ของประเทศในเรื่องของดิจิทัลด้วยนะครับเช่นเราไปเช็คความเชื่อมโยงกับร่างแผน13เช็คการเชื่อมโยงกับแผนปฏิรูปกระบวนการยุติธรรมนะครับเช็คความเชื่อมโยงกับแผนยุทธศาสตร์ตัวใหญ่ของศาลยุติธรรมเช็คความเชื่อมโยงกับนโยบายของท่านประธานศาลฎีกาเป็นต้นนะครับโดยเราแบ่งกลุ่มประเด็นเหล่านี้ออกเป็นตามองค์กรสมรรถนะสูงนะครับ people process culture structure อย่างที่ผมนำเรียนทุกท่านว่าหน่วยงานภาครัฐเนี่ยเขามุ่งสู่องค์กรสมรรถนะสูงมันการเชื่อมโยงผ่านโมเดลขององค์กรสมรรถนะสูงน่าจะตอบโจทย์กับศาลมากกว่าเราก็พบว่าตัววัตถุประสงค์เชิงยุทธศาสตร์ทั้ง11ข้อเนี่ย มีความเชื่อมโยงกับองค์กรสมรรถนะสูงทั้งหมดนะครับไม่มีข้อไหนที่หลุดประเด็นเลยนะครับทีนี้ผมขออนุญาตมาลงรายละเอียดในเรื่องของตัวโครงการต่างๆที่อยู่มาสัก10 กว่าโครงการนะครับโดยที่จะนำในทุกท่านจะเป็นโครงการใหญ่นะครับบางโครงการเนี่ยมีโครงการย่อยเยอะเลยนะครับซึ่งผมอาจจะไม่ลงรายละเอียดของตัวโครงการย่อยเล่า overview ของโครงการใหญ่ให้ฟังเฉยๆนะครับชื่อโครงการใหญ่จะถูกนำด้วย TF เนี่ยคือเอามาจากตัว transformation ซึ่งเป็นหนึ่งในกลยุทธ์หลักของแผนใหญ่นะครับเพื่อให้สอดคล้องกับแผนใหญ่เนาะ TF1 เนี่ยคือโครงการพัฒนา navigation online platform ที่ผมนำเรียนทุกท่านมาแต่แรกนะครับหรือที่ถ้าเกิดเป็นภาษาวัยรุ่นเราเรียกว่า super application คือรวมบริการทุกอย่างของศาลเอาไว้ในแอปเดียวนะครับที่จะเข้าถึงได้ในอุปกรณ์เครื่องมือที่หลากหลายเข้าถึงในมือถือก็ได้เข้าถึงใน PC เข้าถึงใน iPad ก็ได้นะครับเหตุผลที่ต้องเป็นอย่างนั้นทุกท่านทราบดีคนไทยตอนนี้เฉลี่ยมีโมบายโฟนที่เข้าสู่อินเทอร์เน็ตได้ 1.4 เครื่องต่อคนนะครับแต่คนไทยแค่ 70% เท่านั้นนะครับที่เข้าถึงอินเทอร์เน็ตได้ด้วย PC นะครับเพราะฉะนั้นเราอาจจะต้องถึงยุคที่เข้าสู่ซูเปอร์แอปนะครับทุกอย่างทำบนโมบายได้หมดนะครับตอนนี้ศาลเนี่ยมี e-service ย่อยๆที่เราเรียกว่า micro service เนี่ยอยู่เยอะแยะเลยนะครับศาลมีเยอะมากจริงๆนะครับแต่ว่าเราถึงยุคที่เราจะต้องรวม e-service ของศาลเหล่านั้นเนี่ยเข้าด้วยกันแล้วครับออกมาเป็นซูเปอร์แอปเดียวทุกท่านอาจจะนึกถึงแอปเป๋าตังก็ได้ครับอย่างนั้นนะครับคือตัวอย่างของซูเปอร์แอปซึ่งเขาพยายามรวมทุกอย่างมาอยู่ในแอปเดียวรวมไมโครเซอร์วิสทุกอย่างเข้าด้วยกันนะครับให้ผู้ใช้บริการเนี่ยสามารถเข้าถึงได้ทุกบริการจากเครื่องมือที่หลากหลายนะครับมีผู้ใช้บริการสามารถติดตามความก้าวหน้าของกระบวนการของเขาเช่นเขาไปยื่นฟ้องคดีเขาอยากจะทราบว่าตอนนี้อยู่ในขั้นตอนไหนแล้วอีกกี่วันคาดว่าจะดำเนินการเสร็จพวกนี้ควรจะเป็นฟังก์ชันที่อยู่ในซูเปอร์แอปตัวนี้ด้วยนะครับแล้วก็มีบริการที่เชื่อมโยงกับหน่วยงานอื่นในกระบวนการยุติธรรมซึ่งนั่นจะทำให้ศาลเนี่ยก้าวสู่โมเดลที่4ที่เป็นเมกะแพลตฟอร์มที่ผมนำเรียนทุกท่านไปในตอนแรกนะครับสิ่งที่สำคัญที่สุดอย่างหนึ่งของซูเปอร์แอปตัวนี้ Navigation Online Platform ตัวนี้คือจะต้องมีการจัดเก็บข้อมูลผู้ใช้บริการด้วยวงเล็บต้องไม่ขัดกับกฎหมาย PDPA นะครับมีการจัดเก็บข้อมูลของผู้ใช้บริการเพราะตอนนี้ใครเป็นเจ้าของข้อมูลลูกค้าคนนั้นคือผู้ชนะใช่ไหมครับจัดเก็บข้อมูลของผู้ใช้บริการไปทำไมทุกท่านจำวงจร from good to great organization ได้ไหมครับข้อมูลจากผู้ใช้บริการความต้องการความคาดหวังของเขากับข้อมูลที่ความพึงพอใจความไม่พึงพอใจของเขาอะครับควรจะถูกเก็บเข้ามาเพื่อจะทำให้ศาลเนี่ยสามารถปรับปรุงบริการต่างๆเพื่อเพิ่มความพึงพอใจของผู้ใช้บริการให้มากขึ้นเรื่อยๆเพราะอย่างที่ผมนำเรียนทุกท่านไปเมื่อสักครู่นี้ว่า KPI ที่เป็น strategy KPI ของศาลตอนนี้ถูก move ไปที่ outcome ซึ่งเกิดขึ้นที่ผู้ใช้บริการนะครับนั้น KPI หลักๆจะเป็นความพึงพอใจของผู้ใช้บริการซึ่งมันก็คือการวัดเรียกว่า customer satisfaction ที่ทุกท่านทราบดีนะครับแล้วเราจะเพิ่มเป็นตัวหนึ่งที่เรียกว่า customer effort score ด้วยก็คือลูกค้าผู้ใช้บริการศาลได้ง่ายแค่ไหนล่ะนะครับเป็นคนละตัวกับความพึงพอใจนะครับเป็นความง่ายในการใช้บริการพวกนี้คือข้อมูลที่แอปจะต้องเก็บเข้ามาด้วยนะครับเพื่อเข้ามาสู่ Big Data นะครับสำหรับโครงการที่เป็นตัว TF2 เนี่ยครับเป็นโครงการที่เราคาดหวังมากเลยนะครับเป็นโครงการเพื่อที่จะสร้าง innovation ในเรื่องของดิจิทัลใหม่ๆสร้างบริการใหม่ๆขึ้นมานะครับโดยเราคาดหวังว่าทางศาลเนี่ยน่าจะรวมบุคลากร IT จากทั่วประเทศรวมทั้งบุคลากรด้านอื่นที่เกี่ยวข้องด้วยนะครับเพื่อที่จะมาสร้าง innovation team เกิดขึ้น innovation team ที่เกิดจาก talent ในด้านต่างๆที่มีด้าน IT เป็นผู้นำนะครับจากสำนักงานศาลจากศาลทั่วประเทศมารวมตัวกันเพื่อจะสร้าง innovation สร้างสิ่งเรียกว่า sandbox มันท่านผู้บริหารต้องสร้างสิ่งเรียกว่า sandbox ให้ทีมเนี้ยเข้าไปลองเล่น ลองผิดพลาดลองเรียนรู้ได้ตามแนวคิดที่ทุกท่านทราบดี fail fast fail cheap fail forward นะครับ innovation 10 อย่างส่วนใหญ่สำเร็จแค่อย่าง2อย่างเอง Google ก็อัตราการสำเร็จประมาณ 10-20% เองนะครับแต่ Google ก็ดังเลยเนาะนะครับมัน innovation 10 อย่างมันอาจจะสำเร็จแค่อย่าง2อย่างที่8อย่างที่ fail ไปไม่เป็นไรเริ่มต้นใหม่นั้นศาลจะต้องมีนวัตกรรมตัวนี้เกิดขึ้นนะครับมีแซนด์บ็อกซ์ตรงนี้เกิดขึ้นมี innovation team เกิดขึ้น
So, sorry. We gonna develop different services to have the new innovations run under the TF, the transformation project. And we plan to create the metaverses. We can create the hologram, and judges can participate on the meeting platform, and that can provide the kind of classroom experiences also to provide the education. And now we have experiences with meeting on Zooms, and we can look at the icons of the participants, and we can have different functions that show on the right hand side, icons and everything. But we have to develop for the missing parts from Zoom that can be shown on the hologram and the metaverses environment. And then the judges can check and can monitor, for instance, on the left hand side or on the right hand side, what kind of the facial emotions are shown by the participants. And when we transform and enter into Web3 environment, and we can like generate the cryptocurrencies from the trainees who participate in the education or training sessions. But this kind of thing we have to like encourage innovation team to like prepare for to develop, and we can like collaborate with other government agencies and other organizations and to support the judicial system. And I think they are more than happy to support the court transformation. And that's about it for the FT2. And the next project, TF3, we really need it. It is the court big data. It is not the big database, but it is the court big data that collected all the data information from users, from different users into the one big data. After we completed the super app project, all the users or the clients of the court will be collected, and we can further collect all the data onto the big data, and that's about the kind of overview of the big data. The next one, U1. U1 is the judicial process improvement and development. So we can like develop the e-service, e-port, and e-office, and different kind of the digital processes will be developed to support the judicial processes. So it could be programs, applications, including microservices that can provide different kind of services to our clients and providing services to judges and to public. So there, and for next function, it is e-court, focusing on the judges services. And for the e-office, its function will provide for the back office or administrative function of the court. So we identify 11 e-services spreading across functions, starting from the small microservices under the online servicing platform or super apps. I will not discuss in details about it. The following sub-project is e-court. Now we plan to provide services specifically for judges. And the next part, we plan for e-office. So we have a different element that provide different kind of administrative functions. For instance, the e-Saraban, e-HR, and e-form, like we heard from the earlier presentation. That's the U1, and then next one, TF4. The TF4 program is for improving the cybersecurity function, and the next one, TF5. We combine the existing programs or projects existing at the judicial organizations. For instance, we combine all the procurement of the hardwares and softwares for support the court functions. And we combine them, and we provide for supporting the new initiatives. They are all the infrastructure program. And the next one, TF52, for instance, the online hearing program, including the next one, the procurement of the new computers and other sub-program, for instance, the maintenance of the systems and computers. So we combined all the procurement programs into one program. The next one, TF6, it is the program for making analysis of the enterprise architecture. So we look at the court strategy, and we are gonna look at the relationship between different courts functions, and we look at how to come up with the infrastructure, the foundation at the different layers. So we look at how to create the relationship between different data, information to different kind of functions and services. So after that, we have to look at the databases that we have to develop and maintain. And for every 30 years, we need to come up with the reassessments of the enterprise architecture for the future. And the next one, TF7, on the digital re-engineering and organization structuring. And we are look at right now, we have to establish the CDO, the Chief Digital Officers, rather than the CIO. And we are looking at the areas that can affect the HR. We have to restructuring the IT related divisions, and we have to analyze the digital strategy, whether it will affect the number of the personnel, the staff, and I think part of the IT team from different provincial courts have to be at the centralized areas and working at the centralized area. And for this plan, we will gear up the judicial system in Thailand to set up the mega platform. And next one, TF8, the capability building for senior executive, because we for all the senior leaders, including the different levels of the management nationwide, have to be a digital transformation action to involve in the digital transformation action. And under TF9, I will proceed to the TF9. TF9 will be the individual development plan. So next, apart from IDP, it will be individual and digital development plan, IDDP, for each and every personnel. We have his or her own plan for digital development, because each one will have different kind of talent, and we have to understand the ABC process. We have to identify individuals' assets, and then we further build, and then we look at the certification for that individuals. And for the assets part, we have to understand the strengths and weaknesses of each person. So each one we also have the ICDP, the plan that will be response to the organizational requirement. And after that, TC9 will proceed to TF10. So for the TF10, it is the capability building for staff. So we have to understand the ABC cycle: assess, build, and certify according to the international standards. So this slide, I give you the example, the model that we have seen how they certify at the ICDI. We can check their website for their approach, their model, how to improve the capability building. And here is the curriculum for executive and management. The first one for digital management, and here is the example of the curriculum for digital workforce. So starting from module 1, phase 1 on the digital literacy assessment. And the next one, the S1 project. It is related to like identifying procurement for the consultancy for judicial digital transformation. So we laid out the time frame and KPIs have been identified, and we collected KPIs from the digital strategy plan, and then we developed the strategic KPI assessment. So we need to have the appropriate KPIs in the middle of the changing world, and because when there are changes with the environment, with anything, we have to maintain the KPIs assessment, and the existing plan might not be applicable in the changing world. So we need to understand about adjustment to the plan, so that we still can achieve the vision, the so-called VUCA world. It is the vulnerable in this changing world, and we have to keep adjustment to the plans. So we have to like enhance the soft power, enhance the corporate culture, and we have to identify the core values, and we have to focus on digital transformation, and we have to drive, and we have to identify our leaders as role models, and we have to identify the how to change mindset, and that can affect to the behavioral changes, and we have to based on the core values identified. And like I said before, under the digital strategic plan for 4 years, we need to come up with the KPIs, and we have to understand about SROI. It is the social return on investment. What kind of the turnover after using certain number of investment, and we can collect the clear impacts from the investment, and along the process we need to learn, and we need to collect the lessons learned, and we have also need to get the advice from the economists who can advise us on the judicial transformation. So let I talk a little bit about the each year, each fiscal year, what kind of the services we require. Like in 2022, we will develop the online system that will respond for the trading cases, and we have to identify the big data in the 2023, and in 2024, since we're gonna have the e-core with the big data underlying, so we can receive we can have the online system to filtering the cases file online, and 2025 we can have the system to evaluate the feasibility about the building, about the, and we can apply the AI technology. And so that they are the kind of service champion that we have already identified. And we discuss closely with the technology as divisions to come up with different projects. Here are the draft set of the new digital bureau. It could be the new established function, or it could be the new unit under the technology division. So but again, we propose it is the bureau for promoting the digital development. So this specific office will be responsible for development of the super app, for instance, and it will be responsible for data engineering, data scientists, and data analyst team. So there should be a new team based from our discussion, and in order to like expedite the core values realization, and for certain areas there are core values in place already, but again, why not we come up with a new office, a new bureau that can provide the digital support for judges, or else we like cannot realize what we plan within like 3-4 years time frame. So after we have the strategy in place, but it is the living strategy plan, so we have to keep update to the plan and making adjustment to the changing environment. So we can make adjustment to our strategies, right? But we have to adhere to our vision, to our goals. Along the journey, probably we may need to make certain adjustment, but I will not discuss in depth about this. So that's about it, about the digital plan. So may I return the floor to the facilitator. So any questions at this point? I saw the hand raised a while ago. So please, if you have any questions.
ถ้าไม่มีก็เดี๋ยวงั้นเรามาคุยกันต่อก็ได้ครับว่าหลังจากที่ทางอาจารย์สุพัฒน์ได้
So may I proceed after we hear from the assistant professor Supat,
มาช่วยในการมองในอนาคตให้ว่าถ้าเกิด
and why don't we
เดินต่อไปแล้ว
like looking into the future, how we can support so that we can realize the digital transformation, what kind of the pathways, what kind of options do we have. So from what we are working on the different kind of driving forces or any approaches that we can choose. So may I invite Judge Montri. And thank you very much, Professor Subhat, on presenting the digital strategy. So firstly, I'm really appreciated the Judicial Training Institute who organized this meeting. And after we have the digital strategy and digital transformation plan in place, I believe that it is I'm grateful that we have the digital transformation plan, because in the past we only have the general strategic plan, and we heard from the professor, because he pointed out many areas that we have to work further. We have to collaborate and working together, right? And at the technology office under the Thai judiciary, that we have to work closely with them, and we have to maintain our objectives. On my part, what I'm gonna talk, we have seen the big picture, we have seen the high level of everything, right? But there are many key areas that we need to communicate with the senior management, with the senior executives of our organization. So if you look at in the past, we went through different transformations, different kind of changes. But right now, we have to gear up and making the digital transformation, and we have to be like a smart organization. We have to apply the AI technologies to support our jobs. So speaking bluntly, from this specific digital strategy plan, I am please read it through. For myself, I read it, and but we need to come up with the kind of a synchronized mindset, and we need to align different processes, different functions with the plan. And secondly, it is my personal view. This digital strategy plan inspire me, and it should inspire us and create the confidence level of the confidence that we can go further. And the third point, it is about the education, because as a judge, our technological knowledge, I think we are at the basic level of the technological knowledge, and but last but not least, this plan will not leave us behind, but we have to go along with the plan. We have to go further and apply different technologies. I won't spend too much time on this, but on one of the point that I would like to raise up, that when we work on different activities, and then there are different key projects that we need to support them, to realize them. And I would like to highlight three areas. The first one, it is related to the case management system. I believe that at different courts, we are running certain applications, case management applications are run on Oracle system, and we have a certain assets. But I believe that technically for the existing program could not go further. I believe that the case management system is the backbone. It is our backbone, and we can further apply different technologies on top of it. And based on our experiences, we try to transform at different point in time, and we went through the pains, different pain points, and here we are looking for the biggest project, because in the past they are the piecemeal jobs, piecemeal projects. We so if we go on with the existing asset, I think we would go nowhere. My second point to highlight is the we keep developed our own applications. Different areas work on their silos, right? So this kind of thing create problems for the new initiatives. We have to achieve the standards. We have to run on the same standards. I believe that different courts face issues in terms of moving from the legacy system into the new system. So the takeaway from me was that this is a key point about the standardization. We really need commitments from courts. So you have to understand and accept the uniformity, accept the same uniform, same standard for all the courts. But in case you need additional support, I think for the add-in, for instance, it would be fine. But in terms of achieve our goal, we need the standard, right? And we heard from the professor that there are so many things, but it could be difficult to achieve if we do not have the standard. Next one on the innovation, we heard from the professor clearly, right? But I have to speak frankly. Most of the programs will be initiated from the centralized court, centralized judicial system, but we need also the additional innovatives from different offices. It could be from the provincial offices, because you have your pain points, right? And then it will be beneficial for different courts throughout the country, and we have to look at, for instance, we are talking about the procurement online, and another system, for instance, we really need is the appointment system. For instance, the case appointment, we have to appoint the parties of the cases, right? And there are many areas that they are in line with we are thinking about. For instance, our services is for the public, for the general public, right? So for the services, if we can like provide the access to the mobile devices, it can like expand more access to the judicial. And I believe that different initiatives that you mentioned can bring about the disruption. And we have seen a different like statistics that can support for instance for the e-notice system, so we can disrupt the existing service. And my next key area is so
once the first step was done well, what will follow is a flow of information, and the information in the court, as well as the information that the court shares to the public. So I believe that this will lead to more analysis for management purpose, because these information data will become our foundation. We have a central database, and that could be accessed all over the country. But for all this, we need to look that finally, after the transformation, during the transformation, we may have the insufficient devices and equipments, and what do we do about this? But I would like everyone to kind of try to picture all this are leading us to the goal of having a complete data, digital data for the court that can be used and to work to be used further. So I think we need to understand this and do not feel discouraged. We have to go forward together. And the third part is in terms of building the environment that will promote the learning, technological learning. Now, I think this is also important. From the I think that this has been proposed already, but we really need to see to look at the qualifications, potential qualifications for the personnel in the future. What should they look like, and also how we could strengthen that, and also what are the opportunities for learning for the grassroots. And I think we need to work together to develop our personnel. And these are just briefly my comments. And well, after we've got technology and we have adopted technology, there may be some challenges, legal challenges. For example, e-hearing. I can say frankly that this has been developed through a solution for the problems, but e-hearing has been used in a different way. So we need to kind of know which types of hearings are okay to be done online, and which types of cases are not, or types of hearings. So maybe we have to come out with some guidelines and rules for the courts, and even the hearing when we talk about transparency in a hearing, in court hearing. There may be some problems in like important cases, like involving the celebrity, for example, where these are like live streamed online. And there might be, we could foresee challenges like this in the Thai society. There may be requests by the courts, and also we need to look at the challenges that the courts all over the world have faced, and what types of learning and feedback from the public that who can access the hearings online. And I think these are challenges that we will be facing. And many people have said that for AI, for example, AI can, well, maybe can't help, but how much it can actually replace the judges and the court procedures. And I try to look for the information on this, and also opinions on this, and how we can actually move on it. And I just want to confirm that this work together of this plan, it's not just for the Court of Justice. It actually, it's the work of everyone, all the stakeholders that are involved. And we need to have the collaboration so that we can move together. And we've never thought that but that we would go alone, but we want to go together. But in order to move together, we have to see that that is it's not the work of the technological development offices alone. We need to work together, and so that the plan can be implemented efficiently and successfully. Thank you very much. So from the morning, we have listened to on how much technology has been used, and also we talked about integrity, judicial integrity, which is difficult to translate into Thai, but we want to see that kind of the overall appropriateness. And we looked at the definitions that Kun Sarah has shared with us. It's about integrity of the judicial system, but in fact, I don't think there is a problem over this about the judicial independence, due process, and so on. That's already stipulated by the Constitution, and to the separation between the politics and the court, that has been also done. But in terms of technologies, there are two or three issues that are brought up by the Kun Sarah. That is, one is transparency in decision making, transparency in court administration, and then predictability of case timeframes. So these are 2 or 3 items may be more related to the adoption of technology, digital technology in the court system. The issues brought up by Kun Sarah about adopting the technology, we had to ensure access to justice, equal access to justice for all parties, all sectors of society. The minority, including the minorities and the poor and people living in remote areas, the access to justice, the technological use of technology must not create discrimination. and inequalities. But at the same time, there is some kind of problem in practice. For example, we now say that we have e-filing system, electronic documents filing, and that this system provide convenience so people don't have to come to court to submit the paper documents. So that means all the documents are come out in a digital, come in a digital forms, and then we have to we stored it in the machine. But you've seen that the paper filings have how it has actually created the problems of storing all these papers. So, but electronic files can help solve that storage problem, because the cost of storage is not cheap, but in terms of care, like we have rented containers to actually to store the paper or the paper documents. So in the digital system, we want the documents to be in the digital form from the beginning. But that means we force all litigants we cannot force all the litigants to come to use the court services only in a digital format. And of course, the future may be different in 2 3 years, but right now we cannot actually, we're not in a condition to the circumstance to force people to make e-filings, to do e-filings. So so that means that we will have two channels that will continue parallelly. In one way, we encourage people to send to documents or submit documents through the digital channel. But at the same time, we also need to have a counter, physical counter, for people to actually come to the court and to bring the papers, to get the stamp on the files. And that means so we'll have two systems that are continuing at the same time. How do we, and when we do want to have the data to the or in the same format, so that we can do more analysis of this big data, right? One way, the digital format and the paper is actually not not analog. It's just physical paper. Then we need to ensure that we integrate these two channels, so that this is quite a big burden for the courts. We need to scan all the paper documents and to digitize them to ensure that all the data are in the same system. So this involves some practical problems, but we do need to ensure access to the court system for equally for everyone. But of course, the future things may change now that if we do, we can actually provide the internet connection to all over the country, that nobody will be left behind. Then we may be able to see more, ensure more digital data. So when we look at the AI, to the use of AI to process the data, we know that part of the information, the data is not in the digital form. So it's like the having a photograph of the verdict and so on. These facts, the scanned documents, barriers to the use of AI for processing. So because these data are not yet in the appropriate format for AI processing. And this is a challenge for court offices, court officials to deal with and to try to overcome these challenges. In the minds of various stakeholders, including the judges and the court officials, they may not welcome this digital technology that much because it seems to increase their burden, their workload. And because if the case or a lot of cases come in through e-filing and COS, but of course we need to start by looking at that not there will be no system that is completely perfect. When we started using the computers to copy a file from one to another, you have to type C : and so on to get into the floppy, to save into the floppy disk and so on. That's a kind of now a primitive system. It worked, but it caused some bother, but it did not stay, the system did not stay that way for a long time because there will be new developments and new versions. So we, in the same way, we need to look at the digital system in the court, in the courts in the same way. We used the dumb phones, right? Everybody means before we get the smartphones, and the connection was not secure, was not certain, and as well. So we it always started with an imperfect system, and developments will follow. So we need to look at the court system in the same way, that the initial stage is like the it's like the newborn kind of stage. Then it will take time for the baby to grow, to walk, to move, and walking will take some years for walking to turn to running. So we cannot compare our system to trying to aim for the systems that is run by large big tech companies. We have to ensure that the system that we have is adoptable and we can work with it. For example, there are several documents when you have to sign the signature on the documents. Right now, we accept if you just type in your name instead of signature, like my name too. It's like we type in our name without the signature on the digital file. And that's acceptable that as the showing the intention. of the one submitted the documents. But the system, well, now probably will turn into more encryption and e-signature, what so on. But when a new system comes, it's acceptable to us. It has been acceptable to us and at the same level. And we all know that it doesn't have to remain the same. So now is a turning point, our turning point. In the near future, I don't think it will be acceptable for us to just type our name on the e-document. Then we will have to start implementing the e-signature or integrated. But this is already in the plan for the court technological office. So we have a plan to adopt these digital signing, digital signatures. But of course, in the past, just typing your name on a document was easy, but now you may have to produce the e-signature and also some encryption. There are stages and steps that you have to follow. There are definitely more steps, and we'll have to adjust ourselves at the beginning. But this is the future that we will meet. So we have to prepare ourselves for these changes. So when we started to learn to walk, it's acceptable at a certain level, but things will change. And another important challenge that was mentioned by Kun Montri as well is before we teach the AI to learn to analyze the data. This is not to the level or at the level when Kun Sarah talked about predicting the results. Not that level yet, but here for AI to process and sort the data. We're still not ready for this. Because the system mentioned by Kun Sarah called electronic case management. If we don't count e-filings, these data are spread it all over to the different courts. And if you look, you try to pull this data together to synchronize it, it will not happen overnight. And I would say, so it cannot be done at the moment because the fields, data fields for each court are different now, right? The court A has these fields, A, B, and the other court has another data fields. It's basically the results of our administrators who want to report the cases, and then the computer engineer will try to create different fields according to the needs for each court. So the way this is developed differently in the among the courts makes it difficult right now that for us to pull the data together. But what we have to tell the officials and the administrators in each court that we will not be able to pull the data together if each court insists on maintaining the status quo or maintaining the old system, the existing system. But that means that had been developed according to each the interests of each court. So in order to move forward, we need to build a common denominators so that we have a set of data where every court must have a set of fields, data fields. For example, for bail, bail order. There are, in terms of giving the numbers, some courts actually the courts for each court differ, and this is just one task. There are so many different ways of doing it. So in order to build a central database, we need to find a common denominator. Otherwise, it will be impossible to synchronize other data. This is one of the challenge. Apart from this, when you talked about microservices, if you look in the details at the moment, there are about 80 systems in existence. So the technological development office always received the requests, and it seems that everybody wants to have their own system. So these various needs have created a kind of different systems. If there are more of such microservices and the data are spread all over the place and not linked, to synchronize the data, you need to link all the microservices to. I had seen someone's raised the hand, Kun Sirirat. Just go ahead if you have any. I'm with the appeal court now. But when I was working at the civil court, we had a lot of problems on to e-filing or electronic filing is a good thing, but the documents, if there are piles of documents, the 400 and 500 pages, it's very difficult for us to prepare the cases for the hearing. So if we can ask to come out with the identification of all the documents, document 1, 2, 3 or something. Another one is, I think for the witness hearing, people who are responsible to share the relevant documents in the central monitor, so that we don't have to search for it, because this has caused a lot of problems, and we couldn't find the relevant documents. And so there must be some agreements about. Another problem is that if the hearing of the first witness is not completed, and then there's the testimony is keyed in. Usually for me, I would give an order not to scan the testimony until the witness hearing is finished. So if I ask the colleagues, usually they don't give orders, and they just leave it to the assistants. So if you don't give the orders, then they will just keep scanning the testimonies that is not yet completed. So can we set it as a rule that if the hearing of the first witness is not yet finished, then you cannot upload? But I must say that there are the officials, the court officials are actually very overloaded with work. And if we adopt a digital system, if we have to do a court hearing in person, then we should then this then so how can we save time in terms of the sharing of the documents, and also then we need a photocopying machine that can scan the documents as well, because that will help if they can scan multi pages at the same time automatically. I think these are the practical things. So if the technological office can help, it will make our work more efficient. Thank you very much. In terms of technology, we can do everything that we want. It can do everything that we want. About last week, we discussed the link between the court decision to the litigation execution department. So to expedite, then there were some concerns about this typing of the data into the file. If there are errors in filling out the form, then there could be a problem. But in fact, there is a way to ensure that the filling out the forms are correct. There is some way of doing it to make sure that the data are not erroneous.
การสแกนคำให้การพยานใช่ไหมครับอาจจะมีการ
For
สแกน
example, the scanning of the witness testimony, you can start scanning and then set the time and put in the condition before the file can be disclosed. The system-wise, it can be done, but there may be a problem in terms of setting the timing, because once the witness testimony is completed, then maybe you need to set up some system where in the courtroom where the scanning can be automated to be authorized. And but the thing is, you cannot forget to do it, because sometimes we have a problem of the COS system, because some of the documents are like in the system without anybody actually authorize or do something about it. And for separation of the supplementary documents for the charge, the case file, we have an arbitration office, and we do also have e-arbitration system. In that office, we separate the documents into pieces. They can actually be filed separately, and you can also choose that all the documents that have been submitted at the same time, but you can bookmark the documents for certain hearing, witness hearing. The system allow us to do it this way, but in order to use the system, then everyone has to be alerted to this and have to participate. So you know, like separating the files, and in witness hearing, then you can see that you can actually consult the paper documents and show it to the witness. We have seen the judges doing that, but when we change to the bookmark system in the data, it can be done technically, but then those who are users have to actually change their behaviors, their methods too. So you either have to bookmark the electronic files, and so we can call it for at the right places. And your observation is the challenges that we are facing, and we are not sitting still on it. We need to address these challenges. It's just that it's just a matter of what are the priorities, and whether all that are involved are ready to change their ways in respect. For the computer system is easily to be modified, corrected, but to modify people's behavior, it's something else. In many times, we use the computer. We rely on the computer without changing our ways of work. We do notification in a certain way. We continue to do it. And we continue to do it the same way. It's just turning into a digital file. That's all. Kun Sarawut, you have a question? I have been following the IT news, and I have read the master plan. For my comment, usually every project starts in 2026. So that means we wait until then, right? And there are about 10 projects that will be involved in the court. And I think what we need as a priority is a super app. But now we have microservices, which there are 80 of them. So we want super app, just one, but we don't know where to start. And we are in the front row of the users. And as we have gone through the COVID pandemic, and I think we understand now why we're doing this, and no one wants to step back or retreat, but I listen to colleagues talking inside and outside the court. We can comment on everything, but like what Kun Sirirat said, it is one of them. Then the officials, the court officials are complaining about it too, but they don't dare to raise their voice. And we do want to solve the problems that we are facing. What we are facing now is that we don't know where to give the feedbacks on the plan. If there are no feedbacks, and then there are no change. And then if there's no change, you can actually, two things can happen. One is we're not going to go ahead with this plan. And then the other way is to fight and to come up with the more microservices systems and which do not match anything in the central the pool. So I think Also, it will involve money, the resources. I'm sure the initial investment is going to be huge, and it can be, or also to use temporarily too, because we need to invest more. Now, I like the plan, but I think I want to see really the action plan about what we do next, because our organization is so huge, and the central office may want to see this happens, but it may be in the same way. And in a way, we do want to listen to all the stakeholders, but this is a large project and using a lot of budgets. So you have to move forward, and you cannot reach all stakeholders. You cannot listen to all stakeholders. And I've been saying things, but my voice does not reach the central office. So I don't know how we can solve this problem. I know we need people who can speak 3 languages together: the IT language, the legal language, and the administration and management language. And we cannot find this type of person in our organization. We only speak legal language, and we are inferior in terms of the IT and other language. So and I'm concerned that we cannot send the feedbacks. Our feedbacks will not reach the central system. And I think I see that there's a weakness here when there are so many microservices. There are too many in numbers, but also the quality is a problem. So I think e-filing, and e-hailing, these 2 projects, it's version 3 now, right? Version e-filing versions. But we have been using version 3 for 3 years already, and it's basically being forced to use the system because of the COVID pandemic. When I agreed with that, but now COVID is gone or going. So how urgent will the plan be implemented to a certain level? And in specifically e-filings, we don't like paper, and we came out with e-filing version 3, but it's become a PDF files. So we have to read in the same way as paper. So that means the data is not digital. So if you want to gather the data, for processing or for analyzing, it cannot be done. And then so how can we turn the PDF files into structured data? I know that the courts will not be able to do it. So we really need to start we have to identify where to start with the master plan, because otherwise we just continue to use the virtual paper, and it may be important to our sandbox. I'm not confident about the structure of our organizations, and we do lack personnel, right? Even the the public relations policy for the public to use e-filing, the courts of the first instance were not able to try to publicize the information to the public in time. And if the central offices do, it's a type of PR, you say that, go ahead, use it without giving any details. So the problem is the e-filing system. The version 3 probably can replace a paper at about 30%. But then the court officials are actually having to be are the ones burdened with this. Particularly the officials of the court of the first instance. So when we see IT, it's like it's something of a bad luck, because it will increase my workload 3-4 times. So maybe some pilot project like e-filing version 3 has proven that it's good, it is important, but should we not have version 4 now? And I'm not talking about COs yet. That's another thing that we are still confused about. Everybody can access except for the judges, and I'm wondering, like, that's the situation at the moment, is that we need action plan. The master plan, I have followed up on all the master plans, and I think this one is promising, the most promising, but because at least it has some kind of concrete projects. But earlier it was about infrastructure mainly. So when things will come around to the microservices, what do we do? There are some projects that that when I read, I cannot understand well. Like you said, we want data security, and there's a project on blockchain. Why don't they combine these two projects? So we could use the data security, and some later on we want to change the blockchain, and that will be the problem. Right? If we work totally on the digital platforms, everything will be e-notice automatically. We don't need a separate project. So I think the what's existing now is the projects have been kind of each crafted to replace the traditional services, right? So another thing I want to suggest is that there is the central money in all the case files. So once we get the money, then we have to send the money to the bank, and it has to go through so many desks. This is the court fees, and there are so many transactions on this for each case, even so, and there are. So it's basically to acknowledge, everyone has to acknowledge that the money has been deposited in the bank. Can we change this into a wallet, like this money, the central money? Can we change into a wallet system. So the money would be put in the wallet, and once the judges have given order, so that we can convert it. And so this the big task now concerning money, because we need to work with the account the departments, and then the latest at the top is the Bank of Thailand. So and we at the lowest level at the end level we really cannot do. You said that if there are feedbacks and nobody hears you, you can actually look up Kun Montri Silapa Mahabandit, and then and write that you definitely you'll be heard. The question about why setting the projects at 2060, 2029, 26, sorry, 2026. And I think it's just that the budget problem. And when you talk about this money, the fees, and there was a meeting that I raised the issue there. Why do you need the judges to sign the form of the disbursement of the transactions? Why do the judges have to sign? And and they just said that it is according to the regulations, and the regulations can be changed. So in many ways, these are the things that the problems that we really have to deal with. As I agree that talking to the account department, it's not very easy. Please be brief. In terms of the money, whether the two parties can transfer, actually they can transfer directly, don't have to go through the court. Yeah, so at least that would be a big less burden. I propose wallet system because it is a good data to know whether they actually pay on time, and this wallet that can be used to as big data in the big data, though it can be used in other projects too. So I really think that if it's a wallet system, then you can they can do the bank transfer into the wallet. So that means that we also have the data in hand too. And the data will be useful for future analysis and for projects, like the court of the bail order. Actually, this is something that we also want to change in. I think it's about time we become very active at the end, and I am sure that we have time to talk again further. And there are many things that we have to develop further and also to discuss further. What we have discussed so far is interesting, and I hope it's interesting for all the participants. And I think I'd like to finish this session now. Thank you very much.